સંધાન ઓલ ગુજરાત ઇન્ટિગ્રેટેડ ક્લાસરૂમ.
સેટેલાઇટના માધ્યમથી જોડતી કડી એટલે સંધાન.
Good evening, friends. I am Dr. Neepa Vyas, lecturer, Sir Elisha Law College, Ahmedabad. Today we are here to discuss the subject of law, under which today's topic is drafting, pleading and conveyancing. Dear friend, as this whole subject and topic is very vast, I am going to deal with one of the topic of pleadings. Just to start with the topic, I would like to say something about this legal profession. Dear friend, the profession of law is very noble, as well as responsibility is there always on the shoulder of a lawyer. This responsibility is connected with the fate of his or her client. The person who is aggrieved by the action of another person has approached the court to render justice, and the person who helps them to have this justice is none other than but a lawyer. Dear friend, the approach of a lawyer should be in a way that it always helps the client to manage, to render, to give justice to the client, as it is only the lawyer who can argue, who can put the case of his client before the court. So friend, it is the utmost duty of a lawyer to argue the case in such a manner that it helps the client to maintain, to manage his or her fate. The method or the procedure to mention the court, to argue before the court, is nothing but the pleading procedure. As this pleading is a part of drafting, all written documents produced before the court relating to the litigations are draftings. So all draftings, when they are used to plead the case of a client, it becomes the pleadings. What is the meaning of then pleading? Dear friend, if pleading one wants to define, pleading is a written statement filed in the court which contains the issues or the contentions of a party to a claim. In very refined language, when a claim is put in written format before the court, it becomes pleading. If you look into the first slide of today's lecture, drafting of any document to plead the case before the court of law is called pleading. So, drafting of any document which is useful and or which is used to discuss the case before the court of law, it becomes pleading. So, all pleadings are drafting, but all draftings are not pleading. Let me explain this first phrase. All pleadings are drafting, but all draftings are not pleading. See, for example, if power of attorney is prepared by a lawyer relating to one suit, but if that power of attorney is not put before the court for that claim, that will not acquire the title of pleading. So that is only drafting, because it is a written document relating to the litigation. So it is drafting but not used before the court, so it is not a pleading. All pleadings are drafting because once at one time they were written by a particular or a one lawyer. It must be in written format whenever you want to put anything before the court. So all draftings are not pleading, but all pleadings are always drafted. So pleading, which means all written documents, it is put before the court, they are called pleadings. Now dear friend, this pleading, the meaning of pleading is given under Order 6 Rule 1, which says that pleading includes plaint and written statement. As this is the order of CPC, it relates with plaint and or written statement. Dear friend, this pleading is not only the matter of civil suit. Pleadings are also a part of criminal matters. In criminal matters, pleading are considered as complaints. These pleadings, when they are put before any criminal court of criminal jurisdiction, it either be the complaint, but it can never be the FIR, because in criminal cases complaint can be filed either by the individual, or if individual has not filed the complaint, the case will put before the court or magistrate by way of FIR. But FIR can never be considered as the complaint. It is first information report. So in criminal matters also, pleading is a part, and that pleading is in the format of a complaint filed by the individual or any person, whether or not against whom the action or the crime is committed or not. Any XYZ can file a complaint. So pleading is also having connection with criminal cases. As today we are going to deal with pleadings with reference to CPC, this pleading in CPC, as per Order 6 Rule 1, which prescribes the meaning of pleading as this pleading includes plaint and written statement. In very normal language, when any contentions, if they are filed in written format before the court by the plaintiff, becomes plaint. So plaint is the written contentions filed by the party to the claim. So the person who files this plaint is called the plaintiff. Now against whom these contentions are filed, that other party will give an answer in again written format. So that written answer, as per provision of CPC, is the written statement of the opposite party named defendant. So always plaintiff files plaint, defendant files written statement. Now, why these plaint or written statements or pleadings are necessary to be filed before the court? Is there any object? Yes, there are so many objects for filing a pleading, but I have come to the conclusion that there are three main objects of pleading. If you look into the slide, the first object of pleading is to give fair notice to each party of what the opponent's case is. The second object is to ascertain the points to which the parties agree or differ. And the third object is to bring the parties to a definite issue. Three main objects are: the first, to give notice to of the opponent's case. What is the case? What is the issue involved in that claim? To give notice to this issue to the defendant is the first object of pleading. If one files a complaint, if one files any plaint in CPC, under CPC, the first object is the person against whom the claim is filed must be aware which are the claims raised by the other party. The second thing is, this plaint or written statement prescribes the points on which both the parties are agreed or both the parties are differ from each other. X says that I have lended money to B, but B has not paid me back that money. In this fact, X says that money is still not paid by B, but B says that no, money has been paid by me. So their payment of money on that matter, both the parties differ from each other. So to know whether parties are agreed to that or differ from each other, that is the second object of this pleading. And the third object is to bring parties to a definite issue. While filing plaint and the written statement, party will come to the conclusion that on which issue they have to argue, on which issue they have to prove the evidences, on which issue they have to clear the concept or the legal aspects of the matter. So these are the three main objects of pleading. The first, to give notice to the parties about the opponent case. When plaintiff will file a plaint, the defendant will know the points of the claim. So it is the notice given by plaintiff to the defendant. The second is to clear the differences, to clear the agreement, whether they are agreeable on one point or not. That is the second object. And to clarify the definite issues of the claim. So these are the three main objects of pleading. After discussing object, I would like if you read this slide. In criminal matter, pleading begins with complaint. I have already mentioned this point. But what is complaint? Complaint is the oral or written allegations made to a magistrate that some person has committed an offence, but it does not include the report of a police officer. So complaint can be oral or written, which includes allegation made to whom, to which authority? To a magistrate, that some person has committed an offence. So it is the notice given to the magistrate. This notice can be in oral format or in written format if it is a criminal matter. After this oral or written, allegations must be there. Allegations regarding what? Allegations regarding commission of a crime. So in criminal matters, pleading begins with complaint. Complaint means oral or written allegations. In civil matters, this whole language will differ. In criminal matters, oral or written allegations made to a magistrate about crime committed, but it does not include the report of a police officer. Report of a police officer means the first information report. In short, it is known as FIR. So in pleadings with reference to criminal matters, FIR can never be considered as complaint or a pleading, part of a pleading. Now what about civil matters? For civil matter, pleading begins with a plaint. Plaint is a document containing statement of facts prescribing the contentions of the party to the claim. What plaint includes? Plaint includes statement of facts. These statement of facts are related with the contentions. Contentions means the issue, or the contention means the points on which the plaintiff needs the